All right, Ms. Clayton tested negative, which is obviously good, and
No 5-hour energies.
yeah, you never know about those energies.
Stay away from
Ms. Clayton, in cause number 25, DCCR 0446, you were previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
defense agent.
Yes, Your Honor.
Are there any additions or corrections?
No from defense.
Not from the state, Your Honor.
What is everyone's position with regard to the recommendation in the pre-sentence report with regard to her addiction issues? The recommendation is ISF followed by JCDI program.
Again, from the defense, Your Honor, the treatment is a continuum, I suppose, and since she's demonstrated, at least today, that she's drug-free, then I would suggest the court only ISF in advance, just see how she progresses on probation. Maybe perhaps with a drop program.
Well, she's going to go through JCDI for sure,
JCDI.
if at a minimum. Mr. Nichols, thoughts since
I
she
would ask
tested
at least for
negative?
JCDI, Your Honor. She's still underage, but she has a drinking problem and needs to get that dealt with, treated, or under control. And she also smokes marijuana regularly. The facts on this case, she and her friend were heavily intoxicated,
Yeah.
fled from police, lucky it wasn't a
Could've been
crash,
It could have been terrible.
tried to hide out from police around
Yeah,
a.
I know, yeah.
I mean, it could have been a lot worse. And I'll just tell the court from reviewing the video, at least that night, they sure thought it was hilarious. She needs to grow up. She needs to take a little more serious what's getting her here in felony court.
Yeah.
And I'll.
You understand it's not funny. I mean,
I'm never getting
no, I understand that right now, and people do
But
that.
that night, yeah, I do regret everything that night.
So here's the thing, and the seriousness of this is that if you don't do what you're supposed to and get your life on the right track, which is what everyone wants. You're young. We want you to be successful. You're going to get a probation today where you don't have a felony conviction on your record. And if you complete that probation, you're never going to be a convicted felon. But if you violate and you don't take advantage of the programs that we're going to give you, it's going to be difficult because you're at an age where all your friends are going to be doing things that you're not going to be able to do. But the alternative is prison for up to 10 years. So you need to think about that every time somebody says, oh, just come on out with us and do whatever. And your answer is going to be, I'll do that in a few years when I'm not on probation, right? Because I don't want to go to prison for 10 years.
Curfew's important. It's probably one of the most.
Thank you, Your Honor.
Good morning. Are you Julia Schultz? And Mr. Samuel, your client waived the formal reading of the indictment. Ms. Schultz, in cause number 24, DCCR 2290, you're charged with a first-degree felony offense of injury to a child from August 13th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation. And are all of has the rights to all of the children been terminated? Okay.
Yes.
And you understand that a condition of your probation,
And why I put that little caveat in there, Judge, I know it looks kind of silly. There
No.
are some things that Mr. Samuel and I would like to present at the time of the PSI, and we could maybe do an 11 o'clock sentencing whenever we come back.
Sure.
That day, there are going to be very specific terms and conditions that we are going to request of the court. Possibility of special needs, safe P, the absolute requirement that she remain in Jefferson County throughout the duration of the probation, et cetera, et cetera. But the rights, she has relinquished her rights. The father's rights have been terminated as
Okay.
well. You allowed us time to deal with
Right.
that down in family court.
Right.
And I have a memo from Ms. King as well that I think would be informational for the court, and I've also discussed it with Mr. King.
okay,
That's our request.
okay. And you understand all of that, correct? All right. Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Schultz is not competent?
There is none.
right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And on your way out of the courtroom today, you need to stop and talk to probation. I also want to make sure you understand, as a condition of your bond right now and as a condition of your probation, it will be that you cannot be around any child alone under the age of 18. I'm not sure medically if you're still able to have children. I want you to understand that if you have another child, I'm not going to allow you to be around that child. So I can't necessarily stop you. I think legally from having a child, unfortunately, I feel like in some cases I wish I could, but I can tell you that you won't be able to be around that child. So you need to do what's best for you and any future possible children and not have any. Make sense? All right, stop and talk to probation on your way out of the courtroom. And we'll set 5-4. You tested positive this morning for methamphetamines and amphetamines.
I drink a lot of 5-hour powers, like 3 a day, and that's the only thing I think that would make a problem. I've been in Houston with my kids, and I ain't even been around here right now. And I drink a lot of 5-hour powers regularly.
5-hour powers is not going to test positive for methamphetamine.
You know, if you send it off to the lab, I'm sure you'll see it. It's not, I don't do nothing like that. I don't even have the money for that.
Well, all I know is you tested positive for methamphetamine. And obviously there's some concern because you were arrested while this case was pending. And Mr. Coleman figured that out. Hold on.
So it was a traffic ticket.
Just hold on.
I would just observe if it's paraphernalia, that's a Class C and normally does unarrestable. I mean, it is an arrestable offense, but normally it's just a ticket. So jail or fine on the offense.
Doesn't matter. If you're on bond for a felony, you shouldn't. I just asked you not to say anything else right now, okay? I'm just checking on something.
Let her check this.
Obviously, Google and AI is not the end-all be-all, but it is unlikely to cause a positive result on a standard drug test. A 5-hour energy drink does not contain prohibited substance like THC, opiates, or amphetamines. Extremely rare and undetected issues involving cross-contamination during manufacturing would do it, so I don't think that's what we're worried about today. I'm going to grant the state's motion to raise your bond based on the fact that you tested positive, based on the fact that there was an additional arrest while you were on bond for a felony offense. I'm raising your bond in your case. It's currently set at $30,000. I'm going to raise your bond to $75,000. The clerk should give you their paperwork. All right, are you Marquise Berry? And so, Ms. Berry, you're here with your attorney, Mr. Rojas. It's my understanding that the bondsman has filed an affidavit to release surety in your case, which means there's a warrant for your arrest. I don't know what happened with your bondsman, but you have a warrant. There's nothing I can do about that. You're going to have to go with the bailiff this morning. Mr. Rojas can check on that, and we'll see if there's something he can figure out, okay? All right. Yes, sir. Thank you. Mr. Garcia, you tested positive for marijuana, amphetamines, methamphetamines, and ecstasy. Did you drive here? Oh, you're surprised about the ecstasy?
Yeah, I'm surprised about that.
Wow.
I did smoking, I did relapse a few days ago.
Yeah. All right, so I'm going to find, obviously, that is a violation of your bond conditions. I also told you last week specifically that you had to be here on time. No, you were not here. And so I'm going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times, that you also have a GPS monitoring device and remain in Jefferson County since you can't seem to get here on time. We'll figure that out. Talk to your attorney. You can go back.